SJC-10242, Welch versus Sudbury Youth Soccer Association.
Good morning, Ms. Capobianco.
Good morning, Your Honor. My name is Attorney Teresa Capobianco. I represent the appellant, Dustin Welch, in this matter. Today I'd like to present to you three particular points about this appeal. First, when you look at the statute codified at Chapter 231, Section 85V, the legislative intent demonstrates that this particular case is precisely the type of case which the legislature intended to cover through the exception set forth in that statute, the real estate exception. The second point that I'd like to make through my argument is that in this particular case, in their defense, the associations are relying upon their own negligence in order to avoid liability under that exception within that statute. Because they did not properly secure this particular goalpost to the ground, they are claiming that it is something that can be moved so easily such that it should not be considered part of the real estate in terms of the care and maintenance of the real estate.
If we don't agree with you on the first point, though, then the second point naturally flows, doesn't it?
I'm sorry, Your Honor?
If we don't agree with you on the first point, right, then the fact that they may or may not have been negligent is neither here nor there.
Well, Your Honor,
In other words, the whole point of the statutory scheme is there may or may not have been negligence.
there may or may not have been negligence, but what the trial court did not do was once it summarily decided that the immunity provisions of Section 85V applied, it failed to take the next step and then determine whether the real estate exception to that immunity provision applied. And the question that it should have asked was, did these defendants, the associations, have an obligation to secure the goalposts that were within its possession, custody, and control to the fields, which were also within their custody and control? And is the...
Why is that the question? Why can't you go in first through the statutory scheme?
Well, when you look at the statute, Your Honor, the statute, for purposes of this argument, will concede that the statute applies in terms of conferring immunity upon these defendants in this particular case, because there's no doubt that they are a sporting organization, and there's no doubt that this particular injury occurs in the course of them providing an activity consistent with...
was it practice or something?
It was pre-practice. It was just before practice was to begin. So there's no doubt that we'll concede that for the purposes of this argument that the immunity provision does apply. But when you do statutory construction, especially in a case of first impressions such as this, I don't think that it's appropriate to stop at, does the immunity provision apply? Once you determine that the immunity provision does apply, the next question is, do any of these exceptions apply?
No, I understand. I didn't take your case. I wasn't taking your first point to mean you don't look at the statute as a whole. But if we don't agree with you that you get the benefit of the statute, it then doesn't matter whether or not the actors were negligent.
You get the benefit of the exemption.
Of the exemption.
Right. If we don't have, under the case as it's been pleaded, if this court determines that the exemption doesn't apply, that's it.
Yeah, I take it your argument. Right. Your argument is that if these goalposts had been attached to the real estate, then they would have been part of the real estate. Then there would have been a duty to care and maintain them. But they weren't attached to the real estate, and therefore, and the exemption or exception would apply. But they weren't attached to the real estate here, and they should have been. So the very negligence of not attaching to the real estate sort of takes them out of this exemption, something like that.
It places it into the exemption, but I believe our argument actually goes a little bit farther, Your Honor, insofar as when the associations undertook the obligation to provide a field for all of these players, including the plaintiff in this particular case, and they undertake the obligation to maintain and care for the field, that means that these associations must do everything that is reasonable and appropriate in order to provide a field safe for use.
No, but if it's not real estate, right, you don't get the benefit of the exemption. Am I correct?
Your Honor, it depends on what...
No, yes or no?
if this court concludes
No, no,
that
not
the
in the
goal-
facts of this case. If whatever it is not real estate, you don't get the benefit of the exemption, correct?
That's correct,
Right. So you have a field.
right?
Is the field used only for soccer?
The record doesn't show otherwise.
Well, that may make a difference.
They rent it from the town?
The record doesn't demonstrate whether they rent it or not. What we do know,
They
and what
don't
has
own
been
it.
conceded in the defendant's brief, is that they do have the obligation to maintain and control it, and what is pleaded in the
No, wait,
complaint is
wait
that
a
the-
minute. You've got some land, that's real estate.
That's correct.
Right. As I understood your answer to Justice Cordy, you're trying to say, well, because they played soccer there, you can make the real estate more than the land if you affix soccer posts to it. Correct?
That's correct.
If they don't have the right to affix soccer posts to it, or they choose not to affix soccer posts to it, how do you turn that into real estate?
Your Honor, when your obligation is to care for and maintain the soccer field, that includes ensuring that whatever you place upon that soccer field, whatever you place upon the soccer field for the purpose of having or conducting these practices and games is there in such a fashion so as to be safe.
Now, wait a
And-
minute. Are you saying, maybe I misunderstood your answer to Justice Cordy, are you saying that by putting the soccer goals, posts, onto the real estate, it became real estate?
No, that's not what I'm saying, and I would suggest to
Okay.
this court, that's
That-
not necessarily what the statute required the trial court to determine. The statute reads that what will be exempted from immunity is any act or failure to act related to the care and maintenance of real estate. So when you look at the plain language of that statute,
I have to decide what is real estate.
I believe, Your Honor, what you have to decide is whether the failure to properly affix the goalpost to the real estate was a failure to act related to the maintenance of the real estate.
But
If
wouldn't-
they
wouldn't-
don't own the real estate,
Hmm.
do they have any right to affix the goalposts?
They are in possession of the real estate
No, no, no,
and
no,
are
no.
enti-
If they don't own it,
I would submit that, yes, they do have a right to affix it. In this particular case, the fields are being used for the express purpose of conducting a soccer match.
among other things?
Perhaps among other things, but
But it makes a
that's
big
not in the record.
difference. It makes a big difference because in real property, I mean, it may not be in this statute, but in real property, what is sometimes a movable object becomes part of the property. If something has been affixed to the house that you sell, right? You fixed it there. It may become part of the purchase and sale agreement, even though you don't specifically say. I'm sure you see the direction in which I'm going.
Yes, I do, Your Honor. I'm not
So
suggesting,
doesn't there have to be some basis to conclude that the defendants had the legal right to affix something to real estate? Otherwise, how do we get you into the real estate exemption?
the complaint has pleaded that the associations brought these goalposts onto the field for the purpose of conducting soccer practices and games through the associations. And the complaint also has pleaded that the proper way to provide these soccer goalposts so as to render them safe would be to affix them to the ground.
I understand it. Let me give you another hypothetical. Let's assume that you've got a soccer ball and it is left on the field.
Okay?
And, and your client is walking across the field and doesn't see the soccer ball and trips and falls, right? And is injured, seriously injured. And you introduce evidence to say, what you should do in a soccer game is when the players are off the field is take the ball off the field.
Okay.
And in this case, it was negligent not to do that. Does that convert the ball into real estate, to the care and maintenance of real estate?
No, Your Honor. And
What's the difference between the ball and the soccer posts?
The soccer goalpost, first of all, there's two distinctions. First, when you look at a soccer ball, it is small and it is capable of being moved around, and that is the purpose of it. When you look at the purpose of the soccer ball, it's intentionally designed so that it can be kicked, it can be left wherever, and carried to and from games, etc. But a goalpost, on the other hand,
You cannot have temporary goalposts ever?
well, whether you can or cannot, Your Honor, I respectfully suggest is not relevant to this particular case, because in this case we have a goalpost, which is the proper use of that goalpost is to physically attach it or affix it to the ground. And when you look at a goalpost, to finish answering your question, Your Honor, when you look at a goalpost, you can't tell just by looking at it, is that affixed or not going to fix? Is that going to fall on me or not going to fall on me?
Well, that makes it...
Are these goalposts removed after every practice session or after every game? Or are they taken off the field, or are they there for the season?
There is no evidence in the record to suggest that they are
From her point of
removed.
view, it makes no difference.
What we have pleaded in the complaint is that they have brought these goalposts onto the field for the purpose of conducting the organization's practices and matches.
Why isn't your allegation, though, that they bring the goalpost there for the purpose of conducting the game, fall squarely within the actual part of the statute that is, nobody shall be liable, or no organization shall be liable for acts or failures to act in conducting the sports program? They're failing to act by failing to affix. But that seems to me it fits right within the actual immunity part of this statute.
But,
That was-
but
go ahead.
Your Honor, it also fits within the exception, because the failure to act is the failure to properly affix these goalposts to the ground. And when you have the responsibility to care for and maintain the real estate...
Doesn't that mean like you have to fill potholes, or you know, you've got to make sure that you're not tearing up the ground so that somebody's going to fall because you haven't maintained it carefully enough.
Certainly, it can mean that, and it can mean a whole variety of things when you maintain or care for real estate. We know that these associations, in the course of caring for and maintaining the real estate, the purpose of doing that is so that they can provide real estate or provide the fields for the children to play on. And when you envision a soccer field, you see the grass and the striping. It's well mowed, well maintained, but you also see these enormous goalposts.
And you also see a ball.
The ball is carried onto the field by the coaches, by the players, the parents, etc., whereas the goalposts remain at the field.
But
They
you're
are something
saying there's nothing in the evidence to suggest that they do. And it seems to me that if you're not the owner of the real estate, you may not have the right to affix it.
they are in possession and control of the real estate during the practice season. During the soccer season, they are in possession and control of the real estate. The town of Sudbury was the owner of these fields.
But that doesn't determine the legal question as to whether they may not have the right to do all kinds of things. Even they may have a lease. I don't have the terms of the lease, but they may not have the right to do all kinds of things to the real estate, because the town may determine that when it's not soccer season, they want to use the field for something else, and they don't want permanent soccer posts there.
Perhaps that's true in the off-season, Your Honor. It would be advisable perhaps to remove the soccer goalpost, but our position is that during the term of the soccer season, when the associations undertake the responsibility to care for and maintain a field and provide a field for children under the age of 18 to be playing soccer, part of providing that field is to provide the goalpost, which we don't disagree is an integral part of the game of soccer.
Does the record reflect whether or not the general public can use this field when games are not taking place or practices are not taking place?
It does not reflect one way or the other, Your Honor, but I would suggest that this incident could have occurred to any member of the general public and would result in the same type of case being brought forward on that person's behalf. Because if you read the statute, the Goodwin case, which admittedly is a Superior Court case, makes a distinction that perhaps this statute would not apply to persons who are not otherwise engaged in the sport or spectating the sport. But even if you read the immunity provisions broadly, then the statute may apply to just about anybody who's out there. But I believe that what this particular exception is designed to do is to treat associations just like this in the same manner that the legislature and this court has seen fit to treat all other landowners and possessors of land, and that is hold them to the standard of reasonable care. When you're going to provide land, you need to use reasonable care in ensuring that the land is safe for the persons who were to travel upon it.
So is the line you're asking us to draw that if there is equipment which is meant to be affixed to the land, that becomes part of the real estate?
Not necessarily that it becomes part of the real estate, although that does become helpful. The statute specifically, the exception to the statute specifically says anything related to the care and maintenance of the real estate, any act or failure to act related to the care and maintenance of the real estate. And what we're asking this court to determine is that when an soccer association undertakes to provide a field for children to play soccer upon or for other people to walk upon, that if they're going to bring these goal posts onto the field, that they follow the manufacturer's instructions and not be negligent in failing to affix them to the real estate.
So it wouldn't matter to you if this was a Pee-wee soccer game where they have those goals which are fold up and are about 3 feet long, and then you put them with basically tent plugs into the ground. The same rule would apply if those were to blow away and hit somebody.
Perhaps the injuries might be different in that particular case, but the obligation, if you are providing a field, is to maintain it properly. And if you fail to properly affix items which are supposed to be properly affixed, that's negligence, which I believe comes in under the exception to the statute.
Thank you.
Thank you,
Yeah.
Your Honor.
No, it's fine.
Thank you, Ms. Capabianco. Mr. Layton?
Good morning, Your Honor. May it please the Court, my name is Joseph Layton, and I represent the Massachusetts Youth Soccer Association and its member, the Sudbury Youth Soccer Association. Excuse my voice, Your Honor. The notion, I'd like to start, if I may, with what we're talking about here when we talk about these goalposts or soccer nets.
Are they real estate?
They are not real estate. They are large and they are heavy, but they are movable by design. The idea is that they come, I assume, Your Honors, that we've all seen soccer games. These are large nets, and the reason they're not on a concrete foundation or dug into the ground is that in the condition that they're sold, they can be moved around, so an association exactly like my clients can configure and reconfigure these large fields. In this case, it was Haskell Field in Sudbury, a large field owned by the town.
But are they intended to be anchored at some point?
They do often come with anchors, but the anchors are temporary in their design. They're hammered into the ground like tent stakes. Sometimes, if you go to a youth soccer game, you'll see that this same purpose is accomplished by throwing bags of equipment on the back of the net. They can be anchored by weight, or they can be anchored by an actual anchor in the ground. They are not intended to be permanently affixed to the ground by some sort of foundation or digging a hole or anything.
Do they, during the soccer season, do they get moved?
They do, Your Honor. That's part of the reason they're designed this way, because for the older children, you might configure the field one way with 100 yards of playing surface, but then when the small tykes come, you might use additional nets and play across the field. So they are not analogous to fixtures in real estate. They don't become part of the land. They certainly wouldn't follow the land if it were sold. They are products. They
Mr.
are
Layton,
sports.
let me ask you this. We're on a judgment on the pleadings.
Yes, Your Honor.
Does your answer say this? I haven't looked at your answer.
By bringing the motion, it doesn't say that, but by bringing the motion for judgment on the pleadings, we challenge the legal sufficiency of this complaint, because this complaint contains allegations that we are nonprofit associations running a sports program, and that the young plaintiff was a participant in that sports program, and that the allegation is that we breached a duty of care by failing to anchor the nets appropriately. Interestingly, the complaint never mentions, it doesn't say that this duty arises out of control of land. It says that what we failed to do was take a particular action, that is, anchor the nets. We're not saying that we were negligent, and we're certainly not using the negligence as a sword here, but we're saying that the complaint, as worded, says that we failed to take an act, a specific act, that is anchoring this piece of sporting equipment to the ground.
That seems to me to, if that's what it says, fits within this language about you've been negligent in conducting the sports program.
Right, that's our point. Our point is that even if you say that, and even if you were right, and that meant that we were negligent because we didn't anchor it down, this is precisely what the statute covers. That it is about our actions or our failure to take an action. There are times, we were, for purposes of this motion, we concede in control of the field during the practices and the games. And I can think of times in which an association like my client or clients does things with regard to the real estate. I'm specifically thinking of a baseball field. It's customary for baseball teams to groom the field after they use it. Think of ruts in the pitcher's mound. And it would be an interesting and perhaps a close question if an injury arose out of an improperly groomed base path or a rut in the pitcher's mound, because that arguably might have something to do with maintaining the actual real estate that was under the control of the nonprofit. But this isn't that case. This has to do with sports equipment that is just on the field. And if the plaintiff's argument were true, it would have to apply to lots of sports equipment, including the ball suggested by Justice Marshall, but more similar pieces of equipment like those screens that you sometimes see on baseball fields to protect the pitcher during batting practice.
Or bases.
Or bases. Or tennis ball machines that fire balls. There are lots of examples of large sporting equipment that is certainly capable of producing injury, but is still not a fixture on the real estate.
Okay, well, how about football goalposts? Would those fit into the realm of fixtures or sports equipment?
It would be an interesting case, because if we were a youth football program using the town's football field and the goalposts were rusting away, there would be an interesting argument about whether we had sufficient control to fix that goalpost, because it's not our property. But this is not even close to that case. This is more like a situation in which we were a football association, Pop Warner or something, and we had bags, those tackling dummies, left on the field, or even tackling sleds left on the field. Those are sports equipment. They can produce injury, but they're not integrally, that's probably not a word, they're not connected to the real estate in such a way as to bring into play this exception to the rule of no liability.
Well, could a member of the general public come in after a soccer game, or while they're not being, or practice while they're not taking place, come and start kicking a soccer ball around and making use of these nets?
Yes.
And if such a person is injured by the goalpost because it's not, quote, properly anchored, they can bring an action, can't they? Because this doesn't take place during the course of those events.
Right, and I think that would,
Isn't that what the plaintiff is?
No, and I'll be honest, well, of course I'll be honest, I would still be here. I would make the argument that the association is still immune because the placement of the net was still as part of the nonprofit youth sports program, and the statute specifically says that it applies to any person. It doesn't only apply to participants. But your question really brings to mind a Superior Court decision decided by Judge, not Judge Spurlock, Judge Agnes, about a game that was played associated with a girls' softball team, but it was a coach's game. It didn't involve the girls. And he decided that that game wasn't sufficiently within the nonprofit's purpose because it didn't involve the children, and therefore this statute didn't apply to immunize the association under those circumstances. But this accident happened.
Was an appeal taken from that?
There's no appellate decision from that I'm aware of.
I think it was dismissed, he also dismissed it on other grounds.
He did. He
Right,
found
so-
that there was no duty.
Right.
And so he found that the organization had no duty to that particular plaintiff, likening that plaintiff to an actual participant in a sports game. But, I'm sorry, Your Honor.
No, well, I wanted to ask, I meant to ask this of Ms. Capobianco too, but either of you could answer. Is anybody aware of any legislative history about this, what this particular, language about care and maintenance of real estate is?
I am aware of it, but unfortunately, it's not very helpful. I know that the bill was originally introduced by I apologize to him, I forget his name, a representative from Somerville, and originally, as drafted, it applied to real estate, duty to maintain real estate not associated with the game. And my thinking on that is that he was talking about parking lots. Though I don't know. That's just the way I read that original draft. But as passed, they took that out, and it only applies to it applies to real estate. Now, there is one case by this court, a 2002 decision, that doesn't directly involve this statute, but it involves an injury to a cheerleader at Newton High School, and the legal issue was whether a release signed by her father was effective to protect the school. But in that decision, it's called Sharon versus Newton. In that decision, this court discussed this particular statute and said that it was the result of a legislative intention to eliminate tort liability from running these leagues because the legislature had decided that elimination of that liability was necessary to the continuation of these leagues. And I can't remember whether it was implicit or explicit in that decision, but it was clear that because these leagues are run by volunteers and they're good things, the legislature enacted this protection for tort liability.
When the judge says what the defendant nonprofit organizations here provided was essentially a piece of defective sports equipment, that wasn't the allegation in the complaint, was it? I mean, as I hear
Not specifically. The complaint is found on page 4 of the appendix, and it makes very simple allegations that my clients were nonprofits, and that as nonprofits running the programs, they had a duty to affix these nets. Anchor is the verb used. Anchor the nets. It doesn't say that the nets were defective or language like that.
Well, what they're saying is that the reasonable and proper use of said goalposts and nets required that ground anchor pegs or other ground stakes be used to anchor or otherwise secure. And in your answer, I noticed that you denied that. I mean, you said they consist of opinion or representations and constantly do not pertain to defendants, and accordingly no response is required. And to the extent that they do require, as allegations of fact, they denied.
Right. And that's based on the idea, Your Honor, that they're not always anchored, but they are sometimes held down by weight, by removable weight. And in truth, it's often just the teams dump their equipment bags on them, on the back of the net to hold that back piece down. So we denied that they have to be anchored by that method, and that the failure to do it is negligence per se.
Mr. Layton, I take it that the case was filed as many years after the incident because the child, it was filed within the statute of limitations after the child reached the appropriate age?
It was filed before he reached majority, but within the statute of limitations,
Sure.
yes, Your Honor.
Thank you, Mr. Layton.
Thank you.